Good morning and welcome to Advocation's September webinar, the live Q&A, Ask Your Burning Employment Law, Human Resources, and Labor Law Questions, Human Rights Questions. For those of you who are new to the webinar, my name is Hermie Abraham, and I am the Principal Employment Lawyer at Advocation Professional Corporation. We are an employment law firm, and we help both employees and employers serve and solve their workplace issues. Training Thursdays is my desire to help employers and human resources professionals specifically have answers to some of the common employment law issues and questions to basically prevent problems before they happen. So Training Thursdays are held on the third Thursday of each month, and they are held at 9 o'clock every day. There is a different topic each month. So again, tune in live to be able to get the information that you need. Should you not be able to attend, there are replays that are sent back, and I do also try to include a tip sheet to help people with the topic that the webinar focuses on. This week, the tip sheet will include the questions and answers from the live Q&A. Now, a few housekeeping issues. The Google platform has changed with our webinar provider, and as a result, we are doing some work on the background, but it's possible that you might get a black screen that says, "Watch this live on YouTube." If you do get that black screen, and I do promise and hope that it won't be there in October, but if you do get this black screen, click on the Watch Live at YouTube, but do keep your webinar jam, the platform open, because you can still submit your questions and answers through the platform. So just go ahead and click on YouTube. You'll be able to be live. I have already received some questions in advance of the webinar, so I'll go through those questions. But please, if you have questions, do write them in the chat box that is on the right-hand console of your webinar screen. I will go through all the questions possible. We might finish early today. We might be a little later, depending on the questions. If I'm not able to go through all of the questions that have been submitted, I do promise that I will provide answers in the tip sheet. So without further ado, we will get started. And I will start with some of the questions that have already been submitted to me. The first question is, if an employee is found to have committed theft and admits to the theft, can you deduct the stolen money or the value of the goods from the employee's pay? So this was a situation from an employer where an employee had committed some theft of a monetary amount, but wanted to know if they would be able to deduct that money from the employee's pay after the fact, when the employee had admitted and an investigation had turned out that the employee had in fact stolen the amounts. And the law is quite clear in this area under the Employment Standards Act of Ontario that you're not able to make any deductions for any cash amounts or stolen money from an employee without their written consent. So if you are looking to make a deduction from an employee's pay, that's not a routine statutory deduction or a deduction that's required by law, such as a child support obligation that's being served or some kind of judgment debt that's being served, you have to get the employee's writing. Now, there are some situations that even though you get the employee's written acknowledgement, you're still not permitted to make deductions. So for example, if the employee has a shared cash with a group of people, they haven't actually admitted to the wrongdoing, but they are there's a shortage of cash, even if they've signed some kind of waiver that says that, you know, there can be future deductions made against their pay for you know, any losses, the employer wouldn't be able to do so, deduct it in this particular situation if there is some kind of shared cash, simply because there's no way to attribute it to just that one employee or which employee. But where the employee has admitted to it, it's only them who can who could have stolen the money. Then you would be able to make the deduction only with their written consent. Okay, so that's the first question. Second question I have is, one of our employees has resigned and has given 3 weeks notice. If we choose to waive the notice, are we required to pay out the 3 weeks? Now, whenever an employee resigns, the employee is in fact resigning in a future date. So if they're resigning, if they provide their notice to resign today for October 1st, October 1st is the actual date where the employment relationship is coming to an end. So if the employer is seeking to end the employment before that time, it could be construed as a termination, because you're basically then pulling the trigger first, if you will. Now, the best way to guard against this is to have in your employment agreements a provision that says that the employee has to give X amount of weeks to resign, call it 2 or 3 weeks, whatever it is. And if the employee gives that resignation notice, the employer has the ability to waive the notice period in whole or part, and the only obligation will be the last day of active service. So having that type of clause in your employment agreement will definitely help you to be able to have an employee exit sooner than their resignation date without incurring any liabilities. If you don't have that in your employment agreements, and the employee has given a longer period of notice, one thing that you might consider doing is just paying them out what would be the minimums of the Employment Standards Act. And this tends to happen around bonus time. The employee wants to leave, but they want to be there for their bonus. So they might give a longer period of notice, maybe a couple of months or a month or so. And in such situations, you can waive the notice resignation period by only providing the minimums under employment standards. And hopefully that will be able to bridge the period, so you're not necessarily keeping an employee for a very long time if you no longer wish to have them in the workplace. Okay, so that is question number 2. Hopefully everybody can hear me okay. If somebody can just write in and let me know privately to me to let me know that you can hear, that would be great. Second or third question, which was submitted in advance. The company I work for has a matrix reporting structure. This means that although some employees live and work in Ontario, they may report to someone in the United States. The USA office has a work from home program, and some employees who, I guess, report to US managers can work from home. However, there are employees in Ontario who report to Ontario managers and aren't able to work from home. So the question is, are there any laws or guidelines around putting together a work from home policy? And the secondary question, can we open it up to some people and not to others, or does it have to be opened up to all if we go ahead? And the way this works, and this is one area where I say that, you know, discrimination can be legal in the workplace, because you can decide that you're going to open it up to some and not all. And you can make that distinction based on whether or not you report to a manager in the States, and that's permitted, or you could do it based on position, seniority, whatever makes most sense for your organization. So there are no laws that require parity or the ability to treat all employees the same within a workplace. You can treat people differently, and that's completely acceptable. And I would say even with that, there's no requirement that you have to be bound by what is taking place in the US as well too. So simply because the US employees can work from home does not necessarily legally entitle the Canadian employees to also work from home, even if they report to a US manager. You can come up with your own policies and procedures in Canada that work best for you. So I would say that yes, you can definitely treat people differently, and that different treatment can even extend to deciding that in Canada you're going to have a blanket policy that employees do not work from home, and even though some of their US counterparts might be able to do so. So the second question is, are there any guidelines around putting together a work from home policy? So if you are going to be enabling people to work from home, definitely it's important to have a written policy. Policies I refer to as workplace laws. They definitely help you set the tone and be able to ensure that people are participating the way in the program the way you want them to. Some things that you'll want to have in the policy is information about eligibility. So who is eligible to be a work from home employee? Does it depend on the level you are within the organization? Is it based on your service record? Is it based on a department that you might work for? That would be one way to be able to ensure that you can sort of determine who is to be working or working from home when using this policy. The second is you will want to state a very clear purpose of the reason why you have a work from home policy, that you want to offer flexible working arrangements, but it's also a means by which people can continue to work and be productive, because you want to understand that they're not just home doing the laundry, but they are definitely still at work. And again, with that purpose of why you have the work from home policy, you'll want to create standards around how people are to work when they are working from home. So it could very well be that there has to be a secondary number that they can be reached if they can't be reached at the primary number. It can very well be standards around if there's an email or a call that's made, a certain response time that you would expect for them to be able to return. Whichever standards make most sense for your organization and the type of work that the person is doing, you'll want to set those very clearly to make sure that there is no slip in the way work is done simply because somebody's working from home. So that would be my answer to the policy question with respects to what you would want to have in a work from home policy. And also, again, one thing within policies, you'll always want to have a caveat in there that you can make changes as needs be, because you want to be able to be flexible to make changes for your business. Okay, moving on to the fourth question that I have. We extended an offer of employment to an employee and she's to start in 2 weeks. We now wish to revoke the offer. What are our legal exposures, if any? So there's a recent case that came out in BC about an employee who was terminated before their actual start date, and they were seeking, reasonable notice of termination. And the employer was arguing that the employee was under, the probationary period because, they were within that first 3-month period, and as a result, the employment could be terminated at any time. And the court basically found that no, in fact, the employee is not on probation because they haven't even started work, and because they're not on probation, they are entitled to the reasonable notice of their termination, no different than an employee who has been working for you and has lost their job. So in that particular situation, the employee was entitled to 6 months of notice because that was spelled out in contract. So if the contract prevailed, it would be whatever's in contract. If there was no contract or no termination clause in the contract, then it would be based on the written contract, I should say, then it would be based on the common law. So if you are extending an offer of employment to an employee, but then later on revoke it before the employee starts, you are going to have a legal exposure, because chances are this person might have resigned from their previous position and to start your work, and they'll now be forced to look for a job, and they were relying on the fact that they would have a job. So in those situations, you're not going to just be able to walk away unscathed, unfortunately. This is why it's so important to have termination clauses in your employment contract. You can even have a clause that says, up until up until the start date and through to the 3-month period, you will have to use the the probationary clause. So the probationary clause will be what will trigger. That will hopefully, be able to cover, or most likely will be able to cover, your legal exposure. And I think that's also important to bring to the employee's attention ahead of time when you are extending an offer of employment to the employee. And the last pre-submitted question that I had, and this came from one of our previous webinars, we have a use it or lose it vacation policy. An employee who has not taken vacation time for 10 years, employee has not taken vacation time for 10 years, and we are, trying to get her to schedule it. It's not happening. What should we do? So again, if you listen to the vacation, the employment standards webinar that we did, I think that was back in June, and it is in the replays. The vacation entitlement is essentially two parts. There's vacation time and vacation pay. And with this employee with 10 years worth of vacation, there's probably a very large accrual, not only in the time that they have, but also in the pay. Hopefully the pay has been paid out. I always say that annually you should pay out that vacation pay if the person hasn't taken their minimum statutory amount. So pay out the minimum statutory amounts if they haven't used that up. And then focus then on trying to get them to use the time, even if it's unpaid time. So I would say that with this 10-year employee, by the end of your vacation calendar year, ensure that you've paid out any accrued vacation that hasn't been used from previous years. They maybe can carry forward their vacation from their current vacation year if your policy allows you to do that. But if not, pay it out and ensure that there's no vacation pay owing to them, and that you don't have a 10-year accrual. With respect to the vacation time, I would say set a firm deadline as to when the employee should take the vacation, with the caveat that should they not take the vacation by that particular time, they're going to lose the vacation. And I would say that should also be in your policy. Your policy should clearly state that they will lose the vacation time if they do not use it. So give them time to use the vacation. If they don't use the vacation, let them know that then it's going to be forfeited, and you are able to forfeit the vacation with the written agreement and approval of the Director of Employment Standards. And I would say in a situation where you're trying to get the employee to take the time and they're not taking the time, notwithstanding your best efforts, you would be okay to get the approval from the Director of Employment Standards. Remember also that the employer has a right to schedule vacation for the employee. So there are certain situations where there are work blackout periods, and employees can either take the time as an unpaid time off, or they can take it by using their vacation time. So employers can dictate the schedule on how vacation is used. So don't feel, if there is a time that makes most sense, you can sort of force and say to the employee, you have accrued vacation. We would like you to take vacation during this time. There's nothing wrong or illegal about that. So those are the questions I have. There's another one that came in. If employment offer signed 10 years ago, and the company wants employee now to sign a non-disclosure agreement, do we need to provide consideration in exchange for the signing? So this is a great question. Consideration is one of those testy areas of employment law. Whenever you've had a long service or an employee who's been working under contract and you're looking to reintroduce new terms, if you want that non-disclosure agreement to be enforceable, you will have to provide consideration to the employee, because you'll have to exchange some kind of value for the new restrictions that the employee is now going to be undertaking on behalf of your organization. So what is good consideration or valuable consideration in the eyes of the law? Thankfully for employers, it is not defined. But if it's a 10-year employee and this person has been working for, a considerable period of time and producing in a good way, you'll want to make sure that the consideration is fair and reasonable. So I would say, not a day of vacation, which might be something that you would give to a 2 or 3 year employee, an extra day of vacation or extra couple days of vacation. You might want to give an actual signing bonus, maybe, you know, somewhere between $500 to $1,000, maybe even $2,000 at the maximum if they're a more senior level employee, to agree to these non-disclosure commitments. If the employee does not want to sign the non-disclosure agreement, they don't want to accept the consideration, then your option is to basically say, okay, we're giving you notice that effective, you know, this date in the future. If it's 10-month employee, a 10-year employee, I would probably give 10 to 12 months of a future looking time period to say, okay, in 10 to 12 months, we're going to be having a new contract of employment that will apply to you. And in that way, you're actually giving them notice that their employment agreement will be changing in the future. And that notice obligation basically covers you from making a unilateral change. And if the employee continues to work after that particular date, you can at least show legally that you've given them sufficient notice, that they knew that this change was coming, and that they're continuing to work as a acceptance of the new terms of employment. So it does provide you with a greater legal argument for which to use if the employee later on tries to contest that non-disclosure agreement. But I always say that try to update your contracts of employment. You probably have, hence the reason why you're going back to do this non-disclosure agreement. But try to update your contracts of employment so you can go ahead and have all these things in place, the non-disclosures, the confidentiality provisions, and you're not necessarily having to get them midstream during the employment relationship. Also consider that if you're putting new programs together, whether it's a bonus program or increasing the bonus, or even if it's a significant raise that's more than what the employee would typically get, look to introduce contracts at those times, because that would be the additional consideration that you might be providing to the employee. So hopefully that answers the question. I don't have any other questions on the chat right now. If there are any, please do enter them. I will mention a couple of things that are upcoming and that have happened so far. One issue that is the forefront right now in the month of September and became law on September 8th is Bill 132. And Bill 132 is the new harassment prevention legislation that takes the Bill 168 provisions one step further. So employers have a number of things that they need to do to be able to be up to speed with Bill 132 as it's now rolled into the Occupational Health and Safety Act. I'm going to be providing a little checklist for employers, and I'll make sure that I'll send it out to you as well when that's put together. But do make sure that you've audited your policies, and if you have any questions about Bill 132, definitely do contact me. There's another question that's come in. What kind of notice do you need to provide for changes in commission pay plans? Great question. Very similar to the question about non-disclosure agreements. Whenever you're making any type of fundamental change to an employee's employment, it's considered a constructive dismissal. And a fundamental change would be a change to compensation. It would be a change to the working relationship, possibly, if the person's being demoted. It would be a change, if a change in location would be a constructive dismissal. So anything that would be a wide-scale change would be constructive dismissal. Not all constructive dismissals are bad. When you're given a promotion, although they're constructively dismissing your old contract of employment and replacing it for a new one, it's a positive change, and people are happy to work under those new terms. If you're looking to change a commission pay plan, whether it is that you're looking to move salaried employees to commission, and they might be earning the same amount, but they're now in a more variable pay structure, so it's not guaranteed. Or if you're looking to carve off part of their annual salary and make it into a commission plan, you're going to have to give them adequate notice. And that notice is going to be either in the form of, or let me take that back. You'll have to provide them with something of value in terms of consideration. And that would be either providing them a signing bonus for the new signed agreement to the change in the commission plan, the change in their contract, or providing them with notice of the time that this new commission plan is going to take place sometime in the future. And that notice will depend on the common law factors that are used to determine notice for any employee, whether you're terminating them or seeking to make an internal substantial change. And that would look at their age, their years of service with your company, and the type of work they're doing, just to be able to give them enough time, the bridge of time to either decide to continue working under the new contract with you or to find new work if that so pleases them. So notice will either be spelled out in your existing contracts of employment, or you'll have to give them common law notice, but you will have to give notice or signing bonus whenever you're looking to make any fundamental change to aspect of an employee's contract. And I'd say that if you're making a change in contract, make sure that contract change is written and you're having a new written contract of employment. So doesn't look as if we have any more questions, and we're about 4 minutes before the end of the webinar. If there are more questions that come in, as I said, I will promise to provide these questions as the follow-up tip sheet. I apologize for the technical difficulties. I do believe that they will be solved by next week or by next month. The issue is with the Google platform and some changes that have been made. And as a result, there is a bit of a lag time. I think it was up to 90 days. And so we should be good by the next time we have the webinar running. Apologies in advance, but hopefully you're able to either participate live or watch the replay and get value and benefit from this. Again, I thank you very much for your time. I know time is our most precious resource, and the fact that you're willing to spend 30 minutes of your time to be able to listen to what I have to offer is greatly appreciated, and I thank you. I wish you a wonderful day, and again, if you have any questions, please do continue to send them to me. I will, up until, I guess, the end of this week, be putting together the tip sheet, which will have answers to the questions that were asked. Thank you very much, and have a wonderful day.